Now, with this we come to the second important category of rights, that is moral rights. Now, moral rights are in our statute known as author's special rights. Now, they are available, as the title suggests, they are available only to the author, they are not available to owners of copyright. The copyright law marks a distinction between the author and the owner, right. Normally, the default principle is that the author is the first owner of copyright, but then there are certain exceptions as provided in section 17 of the Copyright Act. So, moral rights are always available to the author. Now, moral rights are of two kinds, right of attribution and the right of integrity. Right of attribution is also known as right of identification, right to be identified as an author, right of paternity, and second is right of integrity. Now, section 57 defines and gives us the scope of moral rights. It is worthwhile giving a reading of section 57 here. It says, independently of the author's copyright and even after the assignment either wholly or partially of the said copyright, the author of the work shall have the following two rights. So, before we go to these rights, the nitty-gritty of these rights, let us first understand the opening part of section 57. It is independent of the author's copyright. That means what? Independent of the author's copyright is that there are situations given under section 17 where author shall not be the first owner. There are situations which are exceptions to the default principle of copyright law that says that the author shall be the first owner of copyright, but there are a few situations. For example, a person is working in a newspaper as a writer and he writes and creates works during the course of his employment where the employment was under a contract of service. In such situations, if there is no contract to the contrary, then the employer becomes the first owner of copyright. Now, this expression in section 57 says that independently of author's copyright. That means the availability of moral rights with the author is independent of his copyright. That means whether he was the first owner or not makes no difference to the availability, to the grant of moral rights in favor of the author. It remains as it was, whether he is the owner or he was the first owner or not. The second expression says, and even after the assignment either wholly or partially of the said copyright. We know that copyright, like all other assets, is transferable. So, even if the author of a work as owner had transferred his copyright in favor of another, has sold out as we say in popular parlance, had sold out his copyright to another person, still this sale or this transfer or this assignment or this license would have no effect on the moral rights of the author. Now, another aspect is that this moral right cannot be sold out. Economic rights are transferable, but moral rights are not transferable. With the understanding of this opening part, let us now move to what the rights are. A, to claim authorship of the work. So, the author has the right to be identified as the author. He has a right to claim authorship of the work. And B is to restrain or claim damages in respect of any distortion, mutilation, modification or other act in relation to the said work, if such distortion, mutilation, modification or other act would be prejudicial to his honor or reputation. Let us understand a little in a little detail about these rights. First right is to claim authorship of the work. For example, there is an author who writes a script and he assigns the copyright in the script to a filmmaker. The filmmaker, the producer of the film, makes the film, and in the cast, in the numbering of the film, when the film is shown, he nowhere mentions the name of the script writer. Has the script writer got a right to claim authorship? That means, can he go to a court of law and whereby he can get a direction issued to the producer of the film to include his name within the cast? Yes, that is the exact meaning of the author's right to claim authorship of the work. So, the author can move the court of law and claim a right as against the person who had made a film, because he has used his entire manuscript for his film. So, he must identify the author of the film. The second right is to restrain or claim damages, the right of integrity. If the author has produced a work and thereafter sold the work, has he got the right of integrity? Yes. This right is available in two forms, to restrain or to claim damages. in case his work is subjected to distortion, mutilation, modification or any other similar act, if such similar act, such modification, distortion etc., is or would be prejudicial to his honor or reputation. So, this right is available if there are two ifs, and their two ifs are 1 plus 2. So, the first if is if the work is subjected to distortion, mutilation, modification etc., and second is plus if such modification or mutilation amounts to a compromise or a prejudice to his honor or reputation. Now, very important case was decided by the Delhi High Court in 2005. The name of the case is Amarnath Sehgal versus Union of India. So, in this case Amarnath Sehgal was the plaintiff, who was a very famous an artist of world renown, a very famous sculptor. So, this case revolves around one of the very important official governmental buildings of India, that is Vigyan Bhavan. So, in 1957, when Vigyan Bhavan was constructed newly to house or to organize various international conference, where especially the Prime Minister and the President of India were to be participating. So, in 1957, this building was of Vigyan Bhavan was ready. Now, the then Prime Minister Pandit Jawaharlal Nehru wanted to decorate this building with a mural, with a grand mural. So, he personally invited Amarnath Sehgal, an artist of repute, a sculptor of international renown, to come to Delhi and to see if he could do the mural for the building. Amarnath Sehgal came to Delhi, saw the building and agreed to construct a huge mural, a huge sculpture, an artistic work to be mounted on the main wall of the lobby of Vigyan Bhavan. It took him 6 years to construct a bronze mural and mount it on the wall of the grand lobby of Vigyan Bhavan. Thereafter, it remained on the walls of Vigyan Bhavan. It continued to decorate the walls for nearly 2 decades. Thereafter, the walls of Vigyan Bhavan required repainting and some whitewash and some repair. For that purpose, this huge structure, this huge mural, this huge sculpture was pulled down at the instance of Union of India, because the walls required some repairs and whitewashing. Now, why did they remove it? Why did they break it? Because it was so huge. In order to remove it, it had to be broken, because no door was so big as to, because it was 140 feet wide and 70 feet 140 by 70 feet was huge. So, no door would allow it to pass through. So, in order to get it out of the room, in order to take it out of the room, it had to be broken. That was the logic of the Union of India. So, Mr. Amarnath Sehgal went to the court against this action of the Union of India. Now, the first thing to be decided under the theory, he approached the court under the theory of violation of his moral rights under section 57 of the Act. So, the first question before the court was whether this work was subjected to distortion, mutilation, modification or any similar act. Well, arguments could be raised from both the sides, but ultimately the court decided that it is an extreme form of mutilation, because this was destruction. The Union of India destroyed the work. This destruction the court held to be an extreme form of mutilation. The reason is because it reduced the creative corpus of the author of a work. If, for example, Mr. Amarnath Sehgal had a dozen sculptures of this nature around the world, which were registered in various art galleries and art books of the world of renown, then he would have only 11 now. So, this reduction on the creative corpus of a famous artist would definitely amount to mutilation in the opinion of the Delhi High Court. The second question was whether this mutilation would be prejudicial to the honor or reputation of Mr. Amarnath Sehgal. Well, the court held that certainly, because of the same reason, because in the reduction of the creative corpus of the famous author, this amounts to his it amounts to be prejudicial to his honor or reputation. So, ultimately the court held it to be violative of the action of the Union of India was violative of the moral rights of the author, Mr. Amarnath Sehgal, even though the author had been paid for his work long back. So, such is the nature of moral rights. So, in the end, I would like to summarize whatever I had discussed during the course of this lecture. Through this lecture, we came to understand the nature of copyright, how it is a bundle of copyrights, how various rights are included within this bundle. Broadly, this bundle can be divided into two parts, two kinds of rights. First, economic rights, second, moral rights. Economic rights further could be divided into rights of reproduction, distribution, communication to the public, translation, adaptation, etc. And moral rights could be divided into rights of integrity and rights of paternity. Now, these rights are economic rights are fragmentable, they are transferable, whereas moral rights are not. Moral rights are always available to the author of a work. In no case they are available to anybody else except the author, whereas economic rights are always available to the owner of the work. Thank you very much.